All cell phones on silent, no recording, please. All rise.
Thank you. Be seated, please. All right, the court will call on the record the matters involving State of Wisconsin versus John Rash. The case numbers are 23 CF 120 and 23 CF 528. I'll note that there's a companion case, which is 24 CF 418, which is tracking along today at the defendant's request. These matters are set on for a jury trial, at least the older two, on Monday, and I received some communications from the parties that there may have been at least a partial agreement reached. Am I correct so far where we stand, Mr. Senf?
Yes.
And would you like to state your formal appearance for the record then?
Yes, thank you. Jim Senf appears for the state.
Mr. Rash in person with attorneys Juan Ramirez and Patrick Cafferty.
And Mr. Cafferty, have I accurately stated where your client stands as far as preliminary matters?
The only clarification would be we've reached an agreement on all matters.
Okay. And specifically, there was a request for substitution filed on 24 CF 418, but I believe part of the agreement is that that case will be dismissed and read in here?
Correct, Your Honor.
Okay, so your client's comfortable with me at least handling that case to the extent that decision needs to be made?
Yes.
All right. Mr. Rash, is that correct, sir?
Correct.
All right, very good. So what I'd like to do, or start with at least, Mr. Senf, is to have you put just the limited agreement on the record. I know there's some matters we'll need to be talking about related to the intricacies here, but let's just start there.
Sure. The agreement is the defendant will plead guilty to counts 1 and 2 of 23 CF 120. The remaining counts in that case will be dismissed and read in. Case 23 CF 528 will also be dismissed and read in, as will 24 CF 418. The parties will jointly recommend that the court order a pre-sentence investigation. At sentencing, both sides are free to argue for whatever they believe the appropriate sentence to be. With the caveat, the state will cap its initial confinement term at 15 years.
With there being no specific agreement on extended supervision or the length thereof?
That is correct.
Okay. Mr. Cafferty, is that the agreement?
Yes, it is.
All right. Mr. Rash, is that in fact your agreement?
It is.
Very good. What I'd like to do then is I did receive the plea questionnaire, and this may seem like getting a little bit into the minutia, but I do want to make sure we're all on the same page here. And Mr. Senf, just to walk through the statutory scheme related to these offenses, ultimately in file number 23 CF 120 in counts 1 and 2, the state is charged a violation of 948.025 subsection 1 subsection E based on violations of 948.02. I think it's really self-evident, but it's important to make sure we don't assume things, that the state is alleging that the 948.02 offenses were under subsection 2. Is that, do I have that correct so far?
You do.
Okay. It matters just as it relates to the penalties and what the state would ultimately need to prove as far as the elements are concerned. Is that, Mr. Cafferty, your understanding as well?
Yes, and that is consistent with the second document that we submitted to the court today, which basically summarizes the jury instructions.
Okay. I know you had submitted the plea questionnaire and waiver of rights form previously. You did attach the jury instructions to that. So the only question I had about the jury instructions that you had submitted. I don't know if you have them in front of you, but
I do. With that said, Judge, I have this document, which I think
Okay.
makes it a lot cleaner. If the court would use that, please.
okay. Have you seen this, Mr. Senf?
Yes.
Okay. Okay. This does actually go through a lot of the questions I guess I had in my mind in looking at the initial documents that were filed. So it gets into the specific sexual contact section of the statutes, which I was going to ask some questions about. And it looks like it has the correct specified period of time in it, which I had a concern about. So as far as the elements are concerned, Mr. Senf, you're okay with this document being used to outline the elements here today, it sounds like?
I am.
All right. Mr. Rash, let me just start by saying that we're going to go through a number of documents here today. I'm going to ask you some questions related to those documents. At any point in time during our conversation, if you have a question about what I'm asking you, or if something I say is confusing to you, you can let me know that, number one. Number two, you can also tell me that you'd like a moment to speak to your attorney, and I'd be more than willing to give you an opportunity to do that as well. Do you understand?
I do, thank you.
All right. It's important to me that you understand everything that's going to be happening today, and the best way for me making sure that that happens is just for us to communicate. Okay?
Yes.
Very good. Then in turning to file number 23 CF 120, in count 1, you're charged with repeated sexual assault of a child. This is contrary, as I had stated earlier, to 948.025, subsection 1, subsection E, and is a Class C felony. The maximum penalties are a $100,000 fine, imprisonment for not more than 40 years or both. To that charge, what is your plea here today?
Guilty, Your Honor.
Count 2 charges you with that same offense, the same violation, the same maximum penalties. It does relate to a different victim with the initials KM. To that count number 2 charge, what is your plea here today?
Guilty.
Now, your attorney has handed to me the plea questionnaire and waiver of rights form. Did you get an opportunity to read through this form with your attorney?
Yes.
After reading through the form, did you understand everything contained in it?
Yes, Your Honor.
It looks like it bears your signature on the second page in blue ink. Did you in fact sign this document?
That is correct, yes.
Based upon the date on the signature, it appears that you reviewed it and signed it yesterday. Is that correct?
Correct.
Knowing that about a day or so has passed, is all of the information in this document still truthful and accurate?
Yes, Your Honor.
The form indicates that you're 46 years of age and that you've completed high school with some college education as well. Is that correct?
It's correct.
You do understand the English language okay, and you also understand the charges you've entered a guilty plea to. Is that correct?
Correct.
Are you currently receiving treatment for any kind of mental illness or disorder?
No.
And have you had any alcohol, medications, or drugs in the last 24 hours?
No.
All right. By entering guilty pleas, you're giving up certain constitutional rights. I'd like to talk to you about those here today. First of all, you have an absolute right to a trial in this case. You don't have to engage in the plea bargaining process. You don't have to enter a guilty plea. You could have the case decided by a judge or a jury. Do you understand you're giving up that right?
I do.
At the time of trial, you have a right to remain silent, which means the state could not call you as a witness to testify or comment on the fact that you chose to remain silent if that was your decision. Do you understand you're giving up that right?
I do.
Now, you have a right to remain silent, but you could also testify at trial if you wanted to, or present other witnesses or evidence that's helpful to your case. Do you understand you're giving up your right to do that?
Yes.
If there were witnesses that were out there in the world somewhere that would be valuable or helpful to your case, but they were unwilling to come to court voluntarily, you could issue them a legal document called a subpoena to force them to come to court. Do you understand you're giving up your right to do that?
I do.
You have a right to a jury trial where all 12 jurors would have to agree that you're guilty or not guilty. Do you understand you're giving up that right?
Yes.
You have a right to confront or cross-examine any witnesses that testify against you. Do you understand you're giving up your right to do that?
Yes.
Finally, you're giving up your right to force the state to prove you guilty beyond a reasonable doubt. Do you understand that you're giving up that right?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything of value to get you to give up those rights?
No.
All right. Now, your attorney and I had a discussion a minute ago about the elements of this offense. He's handed to me a sheet which lists the elements of the offenses. Did you go over the elements of the offenses with him?
Yes.
After going over the elements of the offenses with your attorney, do you believe that you understand all of the elements at this time?
I do.
All right. Do you have any questions about the elements that you wish to ask of me at this time?
I do not.
The elements would require that the state prove that you committed at least 3 sexual assaults of the victims with the initials PIC and KM. Do you understand that?
I do.
This specifically relates to a violation of 948.02 subsection 2. The state would need to prove that you had sexual contact with PIC and KM. Do you understand that?
I do.
The state would need to prove further that PIC and KM were under the age of 16 years at the time of the alleged sexual contact. Do you understand that?
Yes.
Sexual contact is the intentional touching of the breast of PIC and KM by you. The touching may be of the breast directly, or it may be through the clothing. The touching may be done by any body part or by any object, but it must be intentional touching. Sexual contact also requires that you acted with intent to become sexually aroused or gratified. Do you understand the state would need to prove that?
Yes.
The state would further need to prove that at least 3 sexual assaults took place within the specified period of time. In this particular case, the specified time is between August 1st of 2017 and July 1st of 2018. Do you understand the state needs to prove that?
I do.
Are you entering guilty pleas today because the state could in fact prove all of those elements if there had been a jury trial?
Yes, Your Honor.
Do you understand that if you are placed on probation and your probation is revoked and your sentence is withheld, you would be brought back before the court and could face up to the maximum penalties?
I do.
Do you understand that if your sentence is imposed and stayed, you would be required to serve the imposed and stayed sentence?
Yes.
I discussed with you the maximum penalties a minute ago. We're going to be setting the matter over for sentencing. There'll be a pre-sentence investigation prepared. At the time of sentencing, the attorneys will have an opportunity to make arguments to me about what they think are appropriate as far as the penalties. The victims will get an opportunity to suggest recommendations, and you'll get an opportunity to talk to me as well about your request for sentencing. Do you understand that's generally how the sentencing process will work?
Yes, I do.
I am not bound by anybody's recommendations, and I can ultimately sentence you to anything I think is appropriate up to the maximum penalties. Do you understand that?
I do.
Do you understand that if you are not a citizen of the United States, your plea could result in deportation, the exclusion of admission to this country, or the denial of naturalization under federal law?
Yes.
Based upon your conviction for a felony here today, you may not vote in any election until your civil rights have been restored to you. Do you understand that?
I do.
Do you understand it is unlawful for you to possess a firearm going forward?
I do.
There's a specific provision in the statutes related to conviction of a serious child sex offense. That information is printed on the plea questionnaire, and it involves you being unable to engage in an occupation or a volunteer position that requires you to work or interact primarily or directly with children under 16. Do you understand that provision as well?
I do.
We mentioned this a little bit earlier, but there are a number of charges and files being dismissed and read in. What that means is that I can consider those charges as part of sentencing you. You could be ordered to pay restitution for those charges if that's applicable, but you could never be prosecuted for those charges in the future. Do you understand what that means?
I do.
Have you had enough time to talk to your attorney about all of your decisions that you've made in court today?
Yes.
Do you need any more time to talk to him?
I do not.
Counsel, are you satisfied that your client's pleas have been made freely, knowingly, and voluntarily made?
Yes, Judge.
All right. And may I use the criminal complaint to form a factual basis for the pleas?
Yes.
All right. Is that acceptable to you as well, Mr. Rash?
It is.
I'll do so. I'll find the defendant's pleas to have been made freely, knowingly, and voluntarily. I believe there's a factual basis for the pleas as well. I'll accept the pleas, find the defendant guilty of those 2 counts. I will dismiss and read in the other matters. That will include 24 CF 418 at the defendant's request. I will order a pre-sentence investigation to be done by the department in this case. We'll set the matter over on a contested basis for sentencing with obviously the limited understandings or agreements that have been reached here. As far as the amount of time needed for a sentencing hearing, I'm thinking somewhere in the 3 to 4 hour range, Mr. Semp. I know there are a number of victims in the cases. I'm not sure how much time you think we need from the state side, but what are your thoughts?
I think that I was thinking more along the lines of 3/4 to perhaps even a full day.
All right. There probably will be witnesses on the defense side as well, I assume. Mr. Cafferty, should we just set it for a whole day and go from there?
I think that's smart, Judge.
We can do that. We'll pick a date. So I apologize. My clerk is informing me that she's having difficulty getting into her CCAP system, so we're just going to have to see if we can fix that, and we'll be right with you. While she's looking into that and we're looking for a date, were there any other matters the state needed to address today?
I have a motion.
Go ahead.
Given the convictions, the fact that we are now post-conviction and there's no presumption of innocence and no right to bond, I am asking that the court remand him.
Mr. Cafferty?
Obviously, we're opposed, Judge. He has now made probably 15 or more court appearances voluntarily. He has cooperated with the process entirely. He does not have any kind of prior record. He and his family live here in the community. There is not a presumption of prison. Each of these offenses is probationable. I don't think there's any reason to remand him at this point.
All right, I'm prepared to address that, and I will address that in a moment. I'm just waiting for my clerk to get back.
March 20th at 8:30.
I can make that work. Good one.
You should be able to log in.
I'm not getting any indication that it does not work, and it is open on my calendar.
Okay, maybe I can just take a straw poll then of the victims. I know there are a number of people in court. Does that date of March 20th at 8:30 not work for anyone? If so, you can just raise your hand and we can have a further discussion. All right, it appears that that date does work then. Mr. Cafferty, I know you had said that that did work for you personally. Did you want to check with any of your folks that you might need at the hearing, or are you good?
We're okay, Judge, thank you.
All right. All right. I'll rule on the state's motion. Before I do so, Mr. Cafferty, were there any other matters that you needed to talk about today?
No, Your Honor, thank you.
All right. As it relates to the defendant's bond and whether to revoke that bond at this time, there are a number of competing factors ultimately for the court to consider. The court needs to exercise discretion. First of all, as it relates to that decision, there is no longer a presumption of innocence in this particular case based upon the defendant's plea. The defendant's plea, I think, cuts both ways. On the one hand, his plea and ultimate taking of responsibility here means that he faces substantial prison time. That's now on the table in this case. And by doing so and by accepting that responsibility, that creates an incentive of risk of flight or failure to appear. On the other hand, by him taking responsibility here today, it does show that he's likely to appear at future court proceedings, including the sentencing date, mainly due to the fact that if he did not do so, number one, he would end up forfeiting the significant cash bond which has been posted in this case, and then number two, he would face additional criminal charges. It could potentially be looked down on him as well as it relates to his character by failing to appear at the sentencing hearing as well. I certainly understand that there are some competing concerns there at this time. I think ultimately in balancing those concerns, an additional factor for the court to consider is the fact that there's going to be a pre-sentence investigation that's done. Ultimately, there'll be collateral information that needs to be gathered as it relates to that document, and there could potentially be a need for the defendant to be out of custody related to that process as well. It might be made more difficult if he's in custody. So as I had said, those are the factors that the court's balancing ultimately in making its decision here today. I do, though, find that given the significance of these charges in this serious situation, I am going to remand the defendant into custody at this time, and I am going to revoke the bond at this point. I just believe that in balancing those competing considerations, it weighs more in favor of remanding the defendant into custody as opposed to not doing so. That is the basis of the court's decision, and I believe that will close the matter here for today. Mr. Semp, was there anything you wish to add before we adjourn the hearing for today's purposes?
I don't have anything else. Thank you, Judge.
Mr. Cafferty, is there anything else you wanted to add or highlight before we conclude for the day?
I did confer with one of the court's deputies. Mr. Rash is a diabetic and brought his accoutrements and medication with him. I'm told he could bring that with him into the jail.
He can, and that will be allowed. And that will be all for today. We'll see you in March.
John, we'll see you next week.